Hi, my name is Cheshta and welcome to the new episode of IP in Business. In this episode, we are going to discuss case Teva versus Sandoz. Before digging deep, let's see what's the history of the case. Sandoz, the appellant, submitted ANDA, that is abbreviated New Drug Application, to FDA, Food and Drug Administration, seeking approval to market generic version of a drug called copazone. Teva, which market this drug, sued the appellants for patent infringement under 35 U.S.C. 271. The patent which is involved in this case is U.S. patent number 5800808A, and the patent claims a copolymer having a molecular weight of about 5 to 9 kilodalton. So what's the problem in this case? The problem in this case is the molecular weight which is mentioned in claim number 1 of the patent. The polymer chemists have actually three different ways by which molecular weight can be calculated, that is peak average, number average and weight average. Now on the basis of this term molecular average, molecular weight actually can be measured by three different methods, but there was nothing written in the claim that by which method the molecular weight was measured in the patent. And on this basis, the molecular weight term is unduly indefinite. Now, what does this unduly indefinite under the standards of 35 U.S.C. 112b means? Patent application or a patent is indefinite if its claim read in the light of specification and the prosecution history fail to inform with reasonable certainty to those who are persons like skilled in art, in this case the polymer chemist, about the scope of the invention. So in a simpler language, polymer scientists or polymer chemists were not clear that by which method the molecular weight was determined in this patent. Earlier, what happened? The district court rejected the appellant's argument that molecular weight is indefinite. District court found a testimony given by Dr. Grant creditable, that MP, that is peak average, is the only type of average molecular weight that can be directly calculated from chromatogram and calibration curve obtained by the analytical method and as described in example number 1. Federal Circuit said that they see no error in the district court decision to credit Dr. Grant's testimony, but Federal Circuit more relied on the intrinsic evidence which came from the prosecution history of the continuation application of the patent. Okay, so Federal Circuit relied on the prosecution history, in which they relied on, there were like two continuation applications, 847 and 539 patents, which are both continuations of application 808, in which patent examiners twice rejected that molecular weight is indefinite for failing to disclose which measure of the molecular weight is used, like it's MP, MN or MW. That is peak average, number average or weight average. And patentee in one instance stated that molecular weight is the best method, and in the other it says it's a peak average. So this created a lot of controversy that which method is actually the right method. So Federal Circuit concluded that they do not convey with reasonable certainty the measure of the molecular weight to be used. In claim number 1 of 808, patentee recites that the molecular weight, without specifying the meaning of that term, is the right method. And parties agree that the molecular weight could be like MP, MW or MN, but they agree that each of these measures is calculated in different way and would typically yield a different result for each polymer sample. So Federal Circuit said that the claim number 1 is absolutely indefinite on the basis that there was a controversy in prosecution history. They were saying something, and in the court with Dr. Grant testimony it was contradictory. So Federal Circuit reversed the decision of district court and said that claim number 1 is invalid for indefinite by clear and convincing evidence. Thank you for watching this episode, and for more queries or if you want any case law to be showcased in this episode, get in touch with us, and you can write to us at info@ipnbusiness.com. Bye bye.